Hi, my name is John Coonley, and I'm the owner of Coonley & Associates. I've been getting a fair amount of follow-up emails about forming limited liability companies, and so I thought it might be helpful to create a video that recaps the meetup I hosted on the topic. I want to remind everybody that these instructions are only for Texas. Every LLC must have a registered agent who has a physical address in the state. And although a social security number is not required to form a company, practically speaking, you need to have one because it's required to get an EIN from the IRS, and an EIN will be required to do even simple things like open a bank account. Although not required, I strongly encourage you to use Form 205. It's easy to forget to include a mandatory section, and the form has all the mandatory fields for you, and the employees at the Secretary of State's office are used to seeing it, so it's less likely to be rejected. Always pay the extra $25 to get filing expedited. If you don't, you could be waiting on your paperwork for weeks. Last, remember to submit your paperwork in duplicate. You must sign both copies, not submit one copy and one original. Your business's name can't be similar to a business name that's already been established or a business name that's been reserved. When they are rejected for this reason, you can get the permission from the person who owns the business with a similar name to give you consent to use the similar name. To do this, you get Form 509 from the Secretary of State's website and get the owner to sign off on giving you permission to use the similar name. Then, when you go to refile the certificate of formation, you submit the Form 509 along with the certificate, and the Secretary of State should accept the proposed name. When it comes to checking on name availability, you can get on the Secretary of State's website and perform an available name search. These cost $1 per search and will save you a lot of hassle and save you the guesswork. Doug Tidwell also suggested going to mycpa.com and searching the franchise tax records for free. That method would probably work for most situations, but probably won't cover reserve names or brand new companies. There is no reason to try to reinvent the wheel by creating your own certificate of formation, although you legally can. As I mentioned, I would highly recommend that you use the standard Form 205 provided on the Secretary of State's website. The form has a nice set of instructions at the top, so if you ever can't remember what to do or need help, it serves as a nice reference. As a side note, if you read the instructions and it references a section of code that you want to look up for yourself, you can use my free app to do it. Available for both iPhone and Android, called Texas Legal Code Search the Law. A registered agent doesn't have any power to control the company, and it doesn't receive any benefit or incur any liability of ownership. It simply is a person or an entity who is responsible to inform the company when there is a lawsuit being brought against it. There are companies that will serve as your registered agent for a fee. Generally, this is a totally unnecessary expense, and either the owner of the business or the business's attorney will be the registered agent. The only requirement for being an agent is that you must have a physical address within the state of Texas, and you must be legally eligible to accept service, which has technical requirements, but practically speaking, it means any mentally able adult. The distinction between members and managers is that members own equity in the company. They are the owners, while managers don't necessarily own the company, but they do make the daily decisions for the company and its operations. Almost every small business is effectively member managed in the beginning because the members are the owners and are also the ones making the daily decisions. So in the beginning, there isn't much practical difference between member managed and manager managed. However, as the business grows, often hiring non-member decision makers is required. So to avoid having to amend the certificate of formation, you can almost never be wrong by filing a manager-managed LLC in the first place. Remember, manager-managed LLCs are run by anybody the members feel to be good managers, but member-managed LLCs can only be run by the members. Some practical advice when it comes to filing the address of the governing person. It makes sense to make the address for the business operations and the governing person the same. If you don't have a permanent office space, getting a P.O. box is a cheap and efficient way to be sure that all of your mail is going to a centralized location. There is no reason to specify a specific purpose in the form field. Many businesses change plans. To me, it doesn't make any sense to limit the types of business activities your business can conduct if you don't need to. The organizer can be almost anyone. It doesn't make much sense to me for it to be anyone other than a member of the business or the business's attorney. The reason being, if there is a mistake made on the filing, the business owner will have to fix it on his dime and with his time. Conversely, an attorney must stand behind their work, and if he or she makes a mistake, they are responsible for fixing it on their dime and with their time. That's a large part of what you're getting when you pay for an attorney. A third party such as LegalZoom makes no such guarantees. Additionally, nobody other than an attorney can legally give you legal advice on matters such as this. In fact, LegalZoom specifically says they are only providing you documents and aren't guaranteeing correctness. With that being said, I can understand why a person would file form paperwork on their own, and I can understand why someone would pay a professional to ensure that it was done correctly. What I can't understand is why someone would pay a third party hundreds of dollars to give them the same paperwork they can get for free on the Secretary of State's website. The only reason you would choose an option on effectiveness of filing that isn't immediate is if the company was being formed for a specific purpose and there was a chance that the triggering event might not occur. In this scenario, you would be saving yourself the hassle of not having to dissolve the company. Additionally, there may be tax reasons to postpone a filing. As an attorney, I understand that my views are often skewed, and whether I intend it or not, I often have points of view that are self-serving. That being said, I would recommend you have an attorney file your paperwork for you, if possible. The reason being, it is nearly a truism that your business will have some sort of legal issue in the future. If that's the case for your business, the first thing the representing attorney will likely do is look up your Secretary of State filings. Even if all things are in perfect order, it still takes time to get the documents and review them. Assuming there are no mistakes, you will likely incur about the same cost for the attorney to review the documents before they're willing to move forward, as you would to have them filed by an attorney in the first place. In which case, if the filings are not correct, they must fix it. So, strictly from an economic standpoint, you really aren't saving much money in the long run by filing the paperwork yourself, and are probably wasting money by having a third-party facilitator like LegalZoom help you file the paperwork. Well, I think I've pretty well covered the fields of the standard Form 205 for filing an LLC. Thanks for watching, and I'd be happy to answer any additional questions you might have.